Hi everyone, welcome to our webinar, Preparing for Major HIPAA Changes in 2022. If you are not familiar with McGuire-Woods, I assume most of you are, but we've been around for 186 years, one of the largest healthcare practice groups in the nation with over 60 attorneys dedicated solely to healthcare. We have 1,100 attorneys in 21 offices, so we really provide full service to our clients. So before we begin today's program, just a little bit of housekeeping. There's a question and answer icon in the lower left-hand corner of your screen. If you'd like to use this to submit any questions, we'll try to get to those if we have time during the presentation. And if we don't have time, we will collect those and we'll follow up with you directly via email. There should also be some additional meeting materials at the bottom of your slide where you can download a copy of the presentation slides. And we're also going to be sending out the slides to you after the program. So if you don't catch those now, we'll send those to you and you can use those for future reference or for your colleagues. And if you are a lawyer, reminder that you are able to get CLE credit for attending this webinar. That's going to be taken care of through your registration. You'll enter your credentials and the McGuire-Woods awesome team will process that on the back end. So, of course, as we have to give a disclaimer, this webinar doesn't create an attorney-client relationship. This isn't legal advice. We're just providing you training and information for you and your colleagues. So if you would like, you have a specific question about something, please reach out to us via email. So this is us. I'm going to kick it over to Jonathan to introduce himself.
Good morning, everyone. My name is Jonathan Ishee, and I'm a partner in the Houston office of McGuire-Woods and a colleague with Andrea of the digital health practice. I have extensive experience advising clients on privacy-related issues, including compliance with state, federal, and international privacy regulations and breach response. I and the team also assist software vendors, providers, health information exchanges, health insurers, and other information technology clients, basically anyone in the digital health space on issues related to digital health, contracting, certification, and regulatory compliance.
Thanks, Jonathan. And I'm Andrea Linna. I'm a partner in McGuire-Woods Chicago office. I also represent companies really at that intersection of healthcare, innovation, and technology. And like Jonathan said, also co-chair our digital health innovation and technology subgroup with Jonathan and our colleague Janice. And I work with healthcare providers and investors really across the spectrum on mergers and acquisitions, data privacy and security, regulatory requirements. I'm 100% healthcare, have been doing this since the beginning of my career. So it's really I'm passionate about this area and excited to speak with you guys today about this important topic. So why are we here? Why listen to this webinar? So this is really the first time in 8 years that there have been major proposed changes to the HIPAA rules. So we wanted to bring this to everyone's attention. Again, these are proposed changes. These are not final changes, but we are expecting that we're going to have final changes probably in 2022, and Jonathan's going to talk about that. But we want to bring this to your attention because there are some things you can be doing now, and you should be aware of kind of what's going to happen in the future. So this proposed rule really came out of a request for information back in 2018, and HHS reached out to the public and basically said, can you submit to us information on how the HIPAA rules are preventing coordinating care to individuals? And how is it burdening providers? How is it, putting all these burdens in place, but not really protecting individuals' right of privacy? And so there was a big response to that, over 1,300 comments to that request for information. It took the department almost 2 years, but then we got this notice of proposed rulemaking in January of this year. And then entities had until May to respond. Again, huge response, 1,500 comments that would be from potentially consumers, covered entities, business associates, industry groups, all submitted these comments about the proposed changes. And so if you're not really familiar with how a notice of proposed rulemaking works, it is just essentially, like I said, a proposed rule. People can comment, and then HHS will now review all of these comments, and it's going to publish a final rule at some point in the future where it will review all the comments, and it typically does so in a very thorough fashion, actually going through the majority of the comments and responding to them individually. So again, the whole purpose of this notice of proposed rulemaking, you'll see this through our presentation, is to transition to value-based healthcare, encouraging care coordination, removing unnecessary burdens, making sure patients have rights to access their information. But at the same time, this provides some difficulty on the behalf of covered entities and business associates, and is going to create some work on their behalf to get up to speed if even some of these proposed changes actually become final. And as far as the compliance date, once we get the final rule, right now it's proposed that you'll have 240 days to actually get in compliance. The department did request comment on whether that is not enough time or it's too much time. So continue to monitor that. That's great that they're giving a good chunk of time to get into compliance. But as you're going to see through this webinar, some of the changes are pretty significant, so you don't want to wait until last minute. Okay, Jonathan, you want to take the next one?
Sure. So one of the questions, as Andrea kind of alluded to in the last slide, that we get a lot of times is, when is this final rule going to be, when is the rule going to be finalized and the final regulations promulgated? We don't have any necessarily insight into that. It's currently unknown. As Andrea kind of mentioned, or Andrea mentioned on the last slide, this rule was originally promulgated in January. They expanded public comment under the notice and rulemaking period for a period of time. It's still out there. It's still going to be, HHS is still reviewing. I had thought that part of the reason why it had been delayed was that there was no director in the position, the director in the Office of Civil Rights. That has now been changed in September. We've got Lisa Pino, who is now the OCR director. And it's, obviously this was a high priority issue for the Biden administration because it was on the spring 2021 unified agenda of federal regulatory and deregulatory actions. So if I was a betting person, I would say that most likely all these actions lead me to believe that there's probably going to be some movement, and the final text of the rule will probably be in the first half of 2022, so the first half of next year. So now that we kind of talked about the background and where we are in the regulatory process, we wanted just to give you an outline of kind of the major provisions and highlights. I won't read the bulleted list, but basically there's some buckets where the changes are kind of, you can bucket them. One is on definitions, either adding definitions or revising definitions. Then there's a bucket of changes to existing requirements related to the ability of patients to access PHI and clarifications of when PHI can be shared without a express written authorization. There's a big section on fees, and this is related to everyone who, if anybody's been following the SIOX ruling that happened related to fees and OCR's guidance related to that. And then finally, there's some things about updating kind of the NIST special publications related to technical specifications. Historically NIST had special publications related to rendering PHI unreadable, unusable, or indecipherable. NIST is planning on, our understanding is planning on updating those special publications with some more additional guidance related to security. So the first big kind of change that I want to bring your attention to is the fact that there is now a definition of electronic health records in HIPAA. So as you guys probably know, the privacy rule does not define the term electronic health record. I can tell you how that term came about. When I was at ONC, I used to work for HHS. We spent like $600,000 coming up with some a report determining on whether we should call it electronic health record, electronic medical record. Electronic health record won out, but when you go through the rule, we never, transferred that from the report to actual regulatory action. HITECH does talk about electronic health records, usually in the context of meaningful use. For all of y'all who are covered in these or at a provider that had to implement electronic health records, you probably remember that the first iteration of this in stage 1 of meaningful use was certified health IT, and then as the stages we moved forward on certification, we started using the term certified electronic health record technology. So this now is going to be a defined term in HIPAA. This is important because the way in which electronic health record is defined is it's an electronic record of health-related information on an individual that is created, gathered, managed, and consulted by authorized healthcare clinicians and staff, and also those individuals have to have a direct treatment relationship with the individual. The reason why I read that out is because, or specifying that is because HIPAA doesn't do away with the concept of a designated record set. So what does this mean to providers in real life? What this means is that you could have patient-related health data in an electronic health record that would be more than what you would traditionally considered in a designated record set. So when a patient comes and asks to inspect their record or get a copy of their record, traditionally you only provide the information that's in the designated record set. Here, it could possibly, and it most likely will be a larger universe of data that you have to provide. And I should also mention that this has some tie-in to the information blocking rules, which I'm sure all of you have heard about and have implemented, that were promulgated earlier this year. So the other big definition that is in HIPAA is this whole new concept of a personal health application. So, currently, there's no even concept of this. When HITECH was passed, many of you probably remember there was this whole concept of a personal health record vendor, and there were requirements for vendors of personal health records, and they let the FTC, the Federal Trade Commission, regulate those personal health record vendors as it relates to privacy. The FTC has promulgated a whole myriad of regulations related to if there's a breach of PHI or in a personal health record vendor, by a personal health record vendor, and what you have to do. Traditionally, that there hasn't been a whole lot of enforcement. If anyone's interested in that, or we have any folks on the phone who are a personal health record vendor, I will put out a plug for a client alert that Andrea and I have written related to increased enforcement by FTC. So that's kind of the history of it. As you can see now, there is a definition. The things that I won't read the definition to you, but the things that I just would highlight is this really gets to the whole idea of breaking down barriers to providing patients or the transmission of health information either to a patient or directed by a patient to a third party. This is because the whole idea of a personal health application is that these applications would most likely use a certified API for electronic transmission of data. As you guys remember, in the information blocking rule and the maintenance of certification criteria for electronic health records, there's a new concept that we're going to move to an API-based transmission standard to try to become truly operable in the electronic transmission of health information. So this is an area where I think there's going to be an explosion of folks creating software to handle this information, these requests, patients wanting to use personal health applications or to get their information, and then kind of the ancillary industry of data aggregation and those kinds of things. So I'm now going to turn it over to Andrea to talk about some other rights or changes to the HIPAA rule.
Yeah, thanks, Jonathan. So these next sections I'm going to cover are really around the modified right of access to PHI. And like we said, one of the main drivers to this rule, and like Jonathan just talked about, access through applications, through apps, etc., is really to make sure that individuals can access their PHI in a broader, more holistic way. One thing I want to bring your attention to before we get into the proposed rules is that there's a lot of action right now from OCR on the current rule. So the current rule is you have to respond to requests for information within 30 days. OCR came out with this right of access initiative where they have started to go after providers. These are large providers, small providers, We've got 20 settlements so far. You can see on the screen a press release that the most recent one was $80,000 settlement. And this is happening now. It's happening during COVID, which was a little bit surprising. But essentially what OCR is doing is they're receiving complaints from patients saying, hey, I've requested my information, and either it's not being provided in 30 days or the extension of another 30 days, or it's being extremely delayed or not provided at all. So OCR now is it started this initiative to really go and figure out what's going on here and fine entities for failure to respond. So my advice right now is, yes, these are proposed rules, but you need to make sure you're complying with the current rules. So I would make sure that kind of a takeaway from this is go back and look at your policies and procedures, go back and look at requests that you've received, make sure you're responding within the 30-day window. It's very, very easy for patients to complain, and then you've got OCR focused on you, and potentially you don't want to be part of this initiative. And so I didn't already say it, these settlements are with large hospital systems, and they're with small providers. So it's, even if you are a solo practice or you only have a few facilities, it doesn't mean you're going to necessarily be exempt from this. These settlements are applying across the board. So take a look at that. It's a good opportunity to make sure that you're complying with the current rule. So through these next few sections, I'm going to talk about proposed changes to different access rights. And here, this is about in-person rights. So the current rule says that patients have the right to inspect and obtain a copy of their PHI in a designated record set. And again, OCR said, hey, this rule's been around since 2013, but we're still receiving all these complaints. Why are we receiving so many complaints if this is not being done? So OCR, in addition to the settlements that are going on right now, is saying we're going to expand this right even more. We're going to allow patients to not only view, receive copies of, but to take notes, to take photographs, to take videos, use any of their personal resources to capture the information. There is an exception where HHS is saying, well, you don't have to require allow the individual to connect like a personal device, like a thumb drive, to your information system or something that could impose, data security issues. But you do need to have essentially a separate space where this individual can go and they can take photos, they can take videos. I think some of the concerns here that come to mind are, if you're a small provider, you're going to have to provide space in your office for individuals to go in and look at their records. You also need to make sure, super important, that this doesn't, yes, the individuals have rights to take videos and pictures, but only on their own information. And so you already have this issue with personal devices where patients are taking pictures of potentially other individuals or using their personal devices in systems and creating some concerns around capturing other individuals' PHI. So this seems to just push that concern even farther. So if this is finalized, this is going to require a change to your policies and procedures, making sure you've got a place for patients to do this, and probably training someone in your workplace that can work with patients in this regard. Okay, the next proposed change, and I've said this a couple times now, is access. You need to provide access 30 days, one 30-day extension. It's current rule. The new rule cuts that in half. You have 15 days with one 15-day extension. And so the concern here is providers are saying, hey, we understand, but at the same time, it's not so easy to comply with these requests. There could be, it depends on the information of the nature of the information requested. So if they're requesting behavioral health information, for example, that may need to be segregated in some way, let's say your records are stored off-site, you need to contact your lawyer about state law or whether 42 CFR Part 2 applies, or you just have a complex entity which is getting tons and tons of these complaints. Like 15 days, we all know as busy professionals flies by. So, that's pretty tight. But what the department is saying is, well, you're already required to do this in a lot of states. So there are 8 or 9 states that already require providers to provide access within 15 days. So like California, Texas, I think Colorado, Tennessee, there's some others. And they're saying you also need, HHS is saying you may also need to put in place even quicker turnaround times for high priority requests. So this is when someone is maybe preparing for urgent medical treatment or something. You need to provide those even quicker than 15 days. So, we'll see if this is finalized. My guess would be it is, just because states are already requiring this. So I think it's going to be hard to make the argument that providers can't have that quicker turnaround time. So what I would do is, again, think about your current compliance, your 30-day compliance. Think about state law. Are you complying with state law? I think that a lot of times is overlooked. We think HIPAA, and we don't think about state law. So to the extent state law is stricter, you have to comply with state law. So make sure that's part of your analysis. I recommend providers to not wait until you receive a request. Have a chart, have a standardized. Make sure if you have facilities in lots of different states, have that ready to go. So you don't necessarily have to call, your lawyer and get the information right away. You've got that ready, and you guys have worked together to prepare that information. Okay, is this you, Jonathan? I think this is your slide, right?
Yeah, yes. So
okay.
One of the other big areas, obviously, that comes up if you have to deal with requests besides the timeliness of responding is the format in which you have to produce the medical records, right? So under the current rule, it requires covered entities to provide individuals access to PHI in the form or format requested by the individual if readily producible. So if you remember when HITECH got passed, this was really the whole idea was it was going to be a binary choice. Like you could either get you could either request and get paper copies of your records, or you could get an electronic copy. But since most of the time when covered entities tried to produce these types of records, they weren't produced. If you got an electronic copy of your data, it was probably a CD that contained PDFs or images, JPEGs on it. It wasn't in a electronic standard that was like machine readable or easily importable into another EHR software platform or a personal health record application. So this has kind of been a big question and a big push by consumer advocates to kind of move this to and also some other industries like personal injury attorneys and some other lawyers and things like that to push HHS to require that if you're going to go through an electronic standard that it's in a machine readable format, commercially in a standard that's commercially adopted. So under the proposed rule, OCR clarifies that readily producible copies of PHI include copies of ePHI requested through secure standards-based APIs, and I should mention it for folks who don't know what API stands for. It's Application Programming Interface, using applications chosen by individuals and copies in any form or format required by applicable state or other law. So one of the questions that has come up is, when you talk about APIs, are we talking about the same APIs that EHR, the certification and maintenance criteria for EHRs are going to use? Is it a different API? Can someone, just request an API and you have to provide it electronically, even if you as a provider don't have that functionality? I think what will happen at the final rule is that OCR will probably provide some guidance and say, well, what we're really trying to get to is when we think about APIs, we're talking about the APIs that were talked about in the 21st Century Cures Act, information blocking rule, standards and maintenance certification criteria. The whole policy behind this is, seamless transmission of data in a machine readable format. So that's probably where they're going, but it'll only time will tell to see what the final rule says. But like I said, if this is kept in the final rule, you as a provider need to start thinking about how am I going to produce this information? Do I have the functionality to do this? Do I need to talk to my EHR vendor? Those kinds of things. And then, also getting familiar with what, especially your medical records or staff or whoever's dealing with this in your IT department about what type of API your system can handle. So, sorry, I'm going to turn it over to Andrea to talk about third parties and requests for third parties for PHI.
Awesome. Thank you. So again, this one's a little interesting. Basically, the right of access requires covered entities to transmit PHI to another person designated by the individual. So this has historically meant they have to provide the request in writing, they as in the individual. It has to be signed, and it clearly has to identify who the PHI is sent to. So they could say, I want it sent to a family member, I want it sent to a healthcare provider, maybe a researcher, if they're participating in some research, or any other person that they choose. So this became an issue in 2020. There was a court case which Jonathan talked about briefly earlier, which this was a lawsuit by a medical records provider, and they essentially contract with providers to deal with all these record requests that providers are receiving. So providers, particularly large providers, may receive overwhelming requests from law firms or insurance companies, and so they've outsourced this requirement to provide these record requests. And so the complainant here said, actually, HHS in 2013 did not have authority to require covered entities to transmit PHI in any form, only ePHI. So before it was, hey, any form that's requested, you have to provide it. And the court said, you're right, HHS did not have that authority. Covered entities only have to provide information in ePHI form. So this proposed rule is basically saying, okay, well, we have to comply with this court case, so we're going to modify the rule. Another way that they change copies to third parties, and this is probably the most concerning from my perspective, is they're saying that individuals can request that their information is sent elsewhere orally, so they don't actually have to put it in writing. As you can imagine, if a patient says to you orally, hey, I want you to send my healthcare record to so-and-so, it's pretty difficult to make sure that you're doing that correctly, right? Like, you don't have any information from them in writing about where they want it sent. There could be a miscommunication. So let's say there's a miscommunication and you send it to the wrong provider because this information is provided orally, not in writing. And now do you have a HIPAA breach on your hands because you sent it to the wrong place? Is this potential for abuse by third parties? What if the patient says orally that they want their information provided, but it's not clear? They only provided a little bit of information, not in a way that was actually clear. So there's a lot of pushback on this. I would be surprised if this is finalized, but if it is, this could potentially be, I think, problematic. It could be a bit of an area where you'd want to watch really carefully. And so then a third requirement, a third proposed change here was requiring covered healthcare providers and health plans to submit a request to another healthcare provider on behalf of the individual. So current and prospective patients of healthcare providers, as well as members that are part of health plans, would have the right to request that their healthcare provider or health plan submit an access request for them on their behalf. So a little bit confusing to think about, but let's say that there's an individual, they're in California, they live in California, they're involved in an automobile accident in Virginia. And in Virginia, they're being seen by a bunch of different specialists, neurologists, physical therapists. The individual could then say to one of those Virginia doctors, hey, you need to reach out to all my providers in California, and you need to make sure that all of my records get over back to the Virginia doctors so they can use that. It makes sense, but it creates a real headache, particularly Large healthcare systems, hospitals, health plans, they might have the resources, the technical expertise, the staffing that would require this coordinating collection of PHI. But if you think about more of your smaller, your solo practices, even mid-sized practices, this is a lot. You know, they're going to have to get out there and request, let's say, from a patient's 3 local hospitals, maybe multiple physician practices, a bunch of specialists. The patient may say, hey, I think I went to these providers, but will you check for me? So it's going to put a lot of burden on the providers to kind of chase down all of these records. So, you know, some serious pushback on this one. We'll see what happens. You know, there's also concern about, gosh, all these different vendors, they may use different kinds of EHR, they may not support electronic exchange. There could be conflicting requirements in state law. So this is one where it could be potentially pretty burdensome to comply with. So we'll be watching that one closely. Another thing to think about, well, the current rule, again, requires requests in writing to send individuals PHI. And what HHS has said is, that's fine, but we can't impose unreasonable measures. So the concern is that even now, you know, you're requiring written notice, but you're requiring extensive information, very long forms. You're requesting unnecessary information. You're requiring the individual to obtain a notarized signature. You're only accepting requests for records through your online portal, or you're requiring unreasonable identity verification. So HHS in this part of the proposed rule is saying, hey, you've got to know more. We can't have these unreasonable requirements. The pushback on this is, what's unreasonable, right? How do we know? And so I think this is one, again, I would guess that this is finalized, but I would suggest that even now, take a look at your current requirements for individuals to receive access to their PHI. Are you asking for anything unreasonable? Is there anything you should take out of there? Are you only giving access if forms are submitted in particular ways or in person or through an online portal? So I'd recommend taking a look at that now, and anything that feels maybe unreasonable, again, that's hard to know what that is. I understand that. But if you don't have a really good reason for having it, you should remove it. Jonathan,
okay, thanks. So the other big area, along with how patients can get their records and who they can send them to, and is the area of fees. And if any of you are a healthcare provider, you know this has been a minefield ever since the rule was originally promulgated. So as you know, the current rule, HIPAA, just says it has to be a reasonable cost-based fee for any copy of PHI. As you know, what had happened after that was that states, you know, traditionally had promulgated, and was usually based on a traditional paper, you know, copying a structure, fees based on, you know, the physical paper model. So usually there was a minimum base and then a per page charge, or a maximum base and then a per page charge you could charge. That was always problematic because I actually had to counsel someone who was getting investigated because they were following the state mandated, they were under the state maximum requirements for paper copies, but OCR was saying that it was unreasonable. And then you kind of had this situation that happened in around 2016 that I kind of alluded to earlier, and that Andrea had mentioned, where OCR had, not through notice and comment rulemaking, but through guidance, had said that when you're charging fees to produce these records, you had to use basically one rate. And what was happening was, and this is kind of the dirty little secret related to medical records companies, was that who produce these records on behalf of covered entities, is that if a patient asks for the record, they would charge one rate, called the patient rate, and then it usually in personal injury or some other type of legal proceeding, if an attorney asks for the same record, they would charge the attorney, you know, 4, 5, 10 times the amount that they would charge the patient. So in 2016, OCR issued this guidance. Remember, it's just guidance saying that you can only charge, you can only have one rate and it had to be the patient rate. Well, this led to the SIOX court case, so it's SIOX versus Azar, in which SIOX, which was a medical records company who did this on behalf of hospitals, said, hey, that's not right. You didn't follow the Administrative Procedures Act in your basically this guidance, you're interpreting it as if it's a regulation, you didn't follow the Administrative Procedures Act, and basically you're crushing our industry because the only way we make money is when we, charge these fees to, usually, like I said earlier, to in response to a request from a personal injury attorney. And what the court determined was, and there were some other issues surrounding the method of access and the format and those kinds of things. But what the court basically determined was, yes, the OCR didn't really follow the Administrative Procedures Act, so that they that couldn't be, you couldn't just arbitrarily decide that you had to charge one rate because the regulations just said it had to be reasonable. So that led to this proposed rule, and basically, and this in the next slide, basically talk about what are the fees that you can charge, and then what about electronic. Like if I request my records and they're, submitted or transmitted to me electronically, is there really any cost involved in that? Traditionally you had paper, you'd have someone, man or woman hours, printing or copying these records. But if it's just electronically and you can submit it, seamlessly through a couple key clicks, why should there be any fees associated with that? So what OCR has decided to do was they have this chart on fees. So basically, if you want to have the proposed rule says if you want to have in-person fee inspection, you can't charge a fee. If you're going to use some type of internet-based method for requesting and obtaining the PHI, either using, you can access it through a portal, you're transmitting it using a API-enabled personal health application, that should be free. If you want an electronic copy for an individual, that should be free. But if you're going to have to ask for non-internet based, like you have to have a CD or DVD, or you want paper-based, that it's still a reasonable cost structure, but it's basically now limited to the labor for making copies and cost of preparing a summary or explanation as agreed by the individual. So you can't just basically what they're trying to do is they're trying to tighten up in a different way the fees that these medical record vendors are charging folks. So it has to be reasonable, but it also you can't just start adding fees that have nothing to do with the preparation of the document. And so the question now becomes, well, does this mean that if I request it from, say, SIOX, and then 2 days later my attorney requests it, it should be the same because they've already prepared it once? Those types of questions. Those types of questions haven't been really resolved in the proposed rule. So I would say just we will wait to see what the final rule says and any sub-regulatory guidance that's provided in the preamble. So moving from fees to healthcare operations, another big area that has come up is what is considered, so in the current rule, as everyone knows, HIPAA has this idea that, the general default rule is that you have to have a written patient authorization before a covered entity can provide PHI to someone. There are a numerous amount of exceptions. The most used one is TPO, which is treatment, payment, and healthcare operations. And healthcare operations, as you guys know, is a very broad definition of what that includes. It's financial, case management, utilization management, those kinds of things. But there have been some questions related to, can we transmit PHI under the healthcare operations exception if the PHI is for an individual and it's related to care coordination? And part of the reason why this is so confusing is that in 2000, to the preamble to the final privacy rule, you know, the preamble talks about certain activities that may be considered either healthcare operations or treatment, and it depending on whether population-wide or patient-specific activities occur, and if patient-specific, whether the individualized communication with the patient occurs on behalf of a healthcare provider or a health plan. So I say all that to say what people were interpreting that language to mean is, well, if you transmit data on a population-based level related to care coordination, it's okay, but if you were to transmit it on an individual level, it would not fit within the healthcare operations exception, and it's not permitted. You'd have to get written authorization. This has kind of become a bigger issue because as we move to, you know, a shift from fee for service to a value-based pay for performance model, a lot of times providers are incentivized to, you know, not just under HIPAA, but just incentivized financially to, you know, get involved in true care coordination because, you know, they're on a risk-based model, or they get some type of bonus at the end of the dates of service related to how well the patient does. So this is a big area. There weren't a whole lot of negative comments. Everybody thought this was a great idea just because it cleared up. And it's funny, if you ever actually read the comments to the OCR's response to the comments, they were kind of like, I don't understand why this is a big deal. We never interpreted it to prohibit individualized sharing of data for care coordination, but I think this is very helpful to know. One area that I will tell you, and this may be very nuanced and archaic for folks, but one of the other issues that has come up and is what about healthcare operations and accounting for disclosures? In the 2018 RFI, OCR wanted to get some input about implementing a requirement to include disclosures by a covered entity for healthcare operations through an EHR and an accounting of disclosures. Basically, OCR punted on that. They said, well, we're not going to deal with accounting for disclosures related to data through healthcare operations and care coordination in this proposed rule. We'll kind of kick the can down the road and determine if we need to take regulatory action at a future date. So now I'm going to turn it over to Andrea to talk about minimum necessary exception.
Thanks, Jonathan. So most of you, if you work in the healthcare space, are probably already familiar with the minimum necessary requirements. So basically, this requires that you know, any disclosure or request, it should really only be the minimum amount of PHI necessary to meet the purpose of the use disclosure request. There are quite a few exceptions to this. This includes, you know, you can provide more than minimum necessary to the patient themselves. The treatment purposes, you can provide more than minimum necessary, and some other ones that we have there on the screen, such as required by law, et cetera. What the new rule is proposing is that you don't also have to comply with the minimum necessary exception for care coordination and case management at an individual level to a healthcare plan or a covered healthcare provider. So this applies individual level, not population-based activities. So for example, if a health plan requests from a provider a disclosure of information for care coordination or case management so that individual member can participate in the plan's new wellness program, the individual provider wouldn't have to second guess what is the minimum amount of PHI that I have to disclose in this situation. So it basically provides some cover and clarity that you don't have to figure that out. You can rely on this exception to say, hey, I'm providing this information for care coordination or case management, therefore I can provide more than what we may consider the minimum necessary amount of PHI that can be disclosed for that purpose. There is some pushback here, there's some hesitancy, as there normally is, about providing information to payers. Are you providing too much? Some providers think that that could lead to discriminatory reimbursement models, intrusion into physician medical decision making, things like that. But again, I think this really is in line with the purpose of these proposed rules as far as this care coordination improvement. So I would anticipate there's still a lot of support for that. So this one is just I wouldn't even call it really much of a change. It's more just of a clarification. So HIPAA already allows covered healthcare providers to disclose PHI to certain health-related social and community-based services. And this is actually allowed under the TPO exception that Jonathan was talking about. And the idea is that you can disclose to social and community-based services if it's part of the individual's treatment. So that T part of the TPO exception, and that an individual's authorization is not required. HHS has come out multiple times, has said this, but despite the fact that that is pretty clearly the rule, many covered entities are very, very hesitant to do that, and they only do so if there's a patient authorization in place. So the department, again, really wants to make sure that there's proper care coordination, which sometimes means that, information about an individual's mental health needs to be shared with supportive housing or wraparound services for individuals to address social determinants of health. And so HHS is saying, hey, this is already the rule, but we're going to put it in explicitly, so you don't have to hesitate. You can provide that information without the individual's authorization. I anticipate this is going to become final because it's already the rule. So I wouldn't anticipate there's going to be much pushback here because it's already what's required. Good faith standard. Here, what the HHS is trying to address is individuals that are experiencing substance use disorders or serious mental illness, and they need key family members and caregivers involved. So currently, the standard is that the covered entity must use its experienced professional judgment to make sure that they can make this disclosure. And HHS is saying, we're going to pull that back some. You only have to use a good faith belief that the disclosure can be made in an individual's best interest. So this would allow, for example, if a licensed healthcare professional always knows that a young adult has overdosed on opioids, they can provide that information to the parent who's involved in the patient's treatment with a good faith belief that the disclosure is in the individual's best interest, not this higher standard of using professional judgment. This also would allow front desk staff, for example, who maybe wouldn't qualify as, quote, using professional judgment, however that's interpreted, to say we can disclose information to caregivers that are always accompanying an adult patient, for example, because that caregiver wants to check in on the welfare of the patient. So this is just I'd say pretty minor change, but it just, again, kind of clarifies it's not such a high standard to share information. So, there's 5 or 6 places within the rule that you're gonna see that change. Another very similar change is allowing covered entities to disclose PHI if they have a good faith belief that the disclosure is necessary to prevent or lessen a threat. And right now, that has to be a serious and imminent threat, imminent being key. And so the proposed change basically says it doesn't have to be imminent. It just has to be serious and reasonably foreseeable. It's very hard to tell if a threat is imminent. So let's say that you get information that an individual is at risk of suicide, they're claiming suicide. Can you disclose if that suicide attempt is only imminent, like is it going to happen very, very soon? That's what you could interpret this rule to say. And basically, HHS is saying that's not really how we want that to run. We want to make sure that as long as it's reasonably foreseeable that this individual could potentially commit suicide, you need to be able to provide that information. Same if there's a threat to public safety, you want to be able to let law enforcement know that there's potential serious harm, even if that attempt is not imminent. So, for example, they use some examples around school shootings and terrorism and different things like that. And this one I actually love as a patient, which I think we all are not only working in the healthcare space or healthcare providers, we are all patients. And over and over, I go to doctors' offices and They make me sign that notice of privacy practices, and it is required under the HIPAA rules. Healthcare providers have to make this good faith effort to obtain your written acknowledgement of the notice of privacy practices. And if you're unable to obtain it, you have to document that you tried to in good faith, and you have to maintain the documentation for 6 years. Everyone knows that's kind of, whatever. We receive this piece of paper, no one really reads it. Maybe it's just posted somewhere. You don't even see the notice of privacy practices. You just acknowledge that you were given the opportunity to review them. This proposal would do away with that, basically saying that's unnecessary paperwork. It also creates a lot of confusion because individuals think that they're signing some sort of waiver. Front desk staff also, frequently think this has to be signed, and even though there's an exception that you just have to use good faith efforts to obtain it, and you can't, hold back care because someone won't sign it. So it just creates confusion, and holding it for 6 years, I think it's acknowledged that that's kind of, at this point, it just doesn't make sense. So the proposal, though, is to, you still have to provide the privacy practices. They don't have to be signed, just a notice. And it will say in there that there's a person available to talk with the patient if they have questions about the privacy practices of the entity. So you would have to have someone available on your staff, provide their phone number, provide their email, and say, are they on site, are they off site, et cetera, and allow the individual to ask questions. So I think that's a great idea. If you have questions, get someone to ask. It's not just, here's this piece of paper that we all have to sign over and over. Okay, Jonathan.
Sure. So kind of along with the proposed rule, NIST, the National Institutes of Standards and Technology, had released in earlier this year kind of a request for comment related to their special publication series, specifically related to HIPAA. As I mentioned at the beginning of the presentation, 13 years ago, NIST issued a special publication related to compliance with HIPAA, but specifically, rendering PHI unreadable, unusable, or indecipherable. It's been 13 years. NIST has asked the community to, respond back as to what type of changes should be made to make sure they can update the special publication series. One thing I would note is, for any of those who are hoping that the NIST, when they update the special publication, is going to provide you with specific technical requirements needed to comply with the security rule, for example, you must use AES 256-bit encryption. Let me just dissuade you of that. While NIST has a role in setting standards on everything from toilet seats to man-portable anti-aircraft missiles, they do not set specific technical standards due to a couple reasons. One being the rapid advancement of technology and the time it takes to go through the rulemaking process. That being said, the result of the request and any updates, can have implications on the security rule, how OCR views, what are the industry best standards that are needed to be used to implement those the security rule standards, and if folks are meeting those or not. So I just say all that to say, keep on the lookout for that. It's usually something that you probably want to review, or your IT department would want to review once they're finalized. So that kind of gets us to our key takeaways. My two key takeaways are that the proposed rules are well intentioned and they're focused on putting patients in the driver's seat as it relates to their information by reducing unnecessary administrative burdens. But at the same time, the proposed rules complicate the current health information disclosure landscape for providers, for medical record information exchanges, those kinds of things. And then the other thing I would say is that the proposed rule advances the push that HHS has had ever since the Recovery Act and HITECH to actually get to a goal of true interoperability, and it builds on HITECH and the 21st Century Cures Act requirements. And for those who are not familiar with the 21st Century Cures Act, that's the information blocking rules and the standards and maintenance certification for EHRs.
Yeah, and just to add to that, yeah, you know, these changes are going to require changes to your policies and procedures. You're going to need to do some retraining. You're going to need to update your contracts, looking at your business associate agreements and the like. So really thinking about, you know, not only taking the time now to look at, okay, what are our current practices? Let's make sure those are in good place. But when these changes do hit, you're ready to go. Again, there should be a good period, a good chunk of time to implement these new policies and procedures, but it takes a while. You've got to figure out how to actually, from a technology perspective, do so, but training up your staff, you know, putting in place those new policies and procedures, it's going to be a lift. And like we said, this is the, you know, the first change in 8 years. So I think that most, you know, entities that are really on top of their compliance are frequently looking at their HIPAA practices. But just as an attorney that works in the space, that's not always the case. We still have many providers that we see across the spectrum, large and small, that, you know, are still trying to get in complete compliance with HIPAA. It's difficult. There's a lot to do. You really need to stay on top of it, and it's high risk, especially now. Like Jonathan said, there's these, you know, security requirements, and the risks are constantly changing. So it's a constant battle. So keep this in mind. Again, these are proposed changes, but once we get those final rules, we want to be there for our clients. We are making sure that we're working on it now, taking our template policies and procedures that we make available for our clients, getting those ready to go with all of these potential changes. And that way, when the final rules come out, we're going to have available quickly for our clients updates to HIPAA policies and procedures. We'll have sample training for your staff, other resources available to you. We're likely going to have updated webinars to explain any changes in the final rule that are different from the proposed rule that we discussed today. So I recommend, if you would like to join our mailing list. This is really how we communicate with a lot of our clients that, you know, maybe we're not talking to on a daily basis about what resources are available to you. Jonathan, myself, and our partner Janice are frequently writing on these issues, as well as many others at McGuire Woods. So it's a good opportunity to stay in touch, make sure you're on top of this, and we of course will be keeping you totally up to speed when we get those final rules. So we're truly monitoring that as much as possible. And, you know, you don't have to worry about reading the thousands of pages of proposed changes. We will certainly take that list for you. So we are very close on time. So I think what we're going to do is take the questions that we've received. We are saving those. We are going to respond to you, give you a call or email you to make sure we can really provide you a holistic response and chat with you about that. So Jonathan, do you want to kick us off here at the end with the podcast?
Sure. So before we close out the presentation, I just want to make a quick plug for our podcast, our Health Plus Tech podcast. In it, we talk to industry and thought leaders about emerging legal policy and technical issues in the digital health space. I highly encourage everyone to subscribe to the podcast, listen to the podcast. Also, if you're interested in being a guest on the podcast, please do not hesitate to reach out to myself or Andrea. We'd love to have you on there. We like to get folks from various, areas, so business folks, IT folks, legal folks, policy folks. So, please do not hesitate to reach out and talk to us, or if you're interested in being a guest, we'd love to have you. So, with that concludes our presentation. So thank you all for attending, and I hope you have a great day.
Thank you, everyone.